everyone, it's Katie from Without a Crystal Ball. Welcome back to my channel. It's Tuesday, February 15th. I hope you had a wonderful Valentine's Day and you're recovering from the big day. I don't know if you celebrate or not, but I hope it was a wonderful day. I was working all morning trying to go through some manuals and guidelines and reading federal rules. And you know, this job is just, you never know what's going to happen on a daily basis. And all of this started because the judge has set sentencing for Josh Duggar. So a couple weeks ago, Josh's attorneys requested a new trial. And they claimed all these things, and basically the government responded and said that there was so much evidence that proved that Josh did this and that he had no grounds for a new trial, no grounds for an acquittal, no grounds for anything to be dismissed. This was a clear-cut case of that Josh did it and he's trying to blame everyone but himself. On the same day, which I talked to you about yesterday, that the government filed their response, his PO filed what's called the pre-sentencing investigation report, which outlines everything to do with Josh and the case and any mitigating factors, talks about, you know, what his risk levels are, all of that. And the instructions along with some statements by people impacted by Josh were included in that. All of that is under seal and will not be released to the public. So once that was filed, they then said, okay, you have until the 25th to respond to this. And here we are today so today is Tuesday. Technically, Josh's attorneys have until the 25th to respond to the government's declaration that they have no grounds for a new trial. But it seems like the judge has made his decision already because he has set up sentencing. It seems as though he's unlikely to give Josh an acquittal or grant him a new trial, because I don't know why he would set up sentencing if he thought he was going to overturn his previous decisions in the courtroom. So he did a text-only order today, basically setting up sentencing for April 5th at 9:30 a.m. in Fayetteville, and it will be Timothy Brooks, the Honorable District Judge, Federal District Judge that presided over his case as the court judge. And the order says that the following. They have deadlines to meet the following. If any party wishes to file a sentencing memorandum, it must be filed no later than 14 days prior to sentencing. A response brief, if desired, is due 7 days thereafter. If the sentencing is continued and any party wishes to submit a supplemental memorandum, such will be due no later than 14 days prior to the new sentencing date, and any response will be due 7 days thereafter. And then he says the government and defense motions seeking a traditional guideline departure must be in writing and filed no later than 4 business days prior to sentencing. So if they want to go beyond the guidelines that are set by the federal government, that's due 4 days before sentencing. So there are specific guidelines that are set up by the government of maximums and minimums, but the government actually gives discretion to judges to, if they feel like there's a reason that they need to go above a mandatory maximum or below a mandatory minimum, they have that discretion, but they have to be able to prove all of that and provide reasons for that during the sentencing phase. And then it says no later than 3 days prior to sentencing, counsel must confer and advise the court via email as to any substantive PSR objections which remain outstanding and require court resolution. As to each such objection, counsel are to state in an email whether an evidentiary hearing will be required, the number of witnesses each party may call, and the approximate length of time necessary for the evidentiary portion of the hearing. And that was signed by the judge. So all of this is very standard, but a lot of you guys are wondering what this means for his sentencing and what they could recommend for sentencing. And I have done my best to sort of stay out of the weeds because, first of all, I don't know I am not an expert in sentencing. I am not someone that works in the federal court system. I can only go off of what guidelines state, and even then, those are guidelines. There are a variety of different factors that play into it, and without having access to his pre-sentencing report, we don't know all the mitigating factors that the court will be considering until the day of sentencing. But I did look up the manual for the specific charges for Josh, and he was technically indicted on 2 separate counts. One of the counts was stayed, and then the other one, because it was a lesser included charge for the same offense. So one was receipt, meaning that he knowingly downloaded and obtained content off the internet, and then the other one was possessing. In order to possess, you have to receive. So it's kind of like they're included. So they got rid of the possession charge, and then they're basically charging him with the higher offense of receipt. So all receipt charges are sort of in the same bucket as distribution, receipt distribution, and there's special categories of these sentencing guidelines that can be used to either increase what the sentence would be or decrease sentence would be based on the guidelines. So I was spending some time today and I went through because I wanted to remember what Justin Roberts had said to Josh's attorneys in March of 2021 to make clear what they told Josh's attorneys when they were still trying to determine a plea deal. So in 2021, in March, for his grand jury indictment, the government, Dustin Roberts and Carly Marshall, they approached Josh Duggar's attorneys and explained all of the evidence that they had. They provide him all of the details, all the forensics that they found that prove that Josh did this, and they present him with an opportunity to take a plea deal. And they sent him a proposed plea deal along with a waiver of a grand jury and basically giving him an opportunity to take responsibility and not having to go through the lengthy process of a court, getting the jury, going through all the evidence. And the problem here is that he declined this, which means that gave the government more opportunity to get familiar with Josh, anything else he might have been involved in, and then all of that evidence was presented in court. So plea deals can likely have a lesser sentence because not all the evidence or not all the details are revealed yet, and then the judge doesn't see all the evidence either, or doesn't hear all the testimony because all of the witnesses that testify, and then the jury, think of what the jury had to go through here. They basically presented this to Josh as kind of like a typical run-of-the-mill standard case, but they said this is what they told him in regards to what the offer would be, but it wasn't a formal offer. So they said the defense likewise inquired about the applicable sentencing guidelines, and the government's attorney stated that the defendant would hit all the enhancements, which would likely result in the guideline recommended sentence of around 10 years. However, there was no oral agreement as to sentence or promises regarding the accuracy of the guideline estimate provided. They offered and said, if we go off just what we know right now, we estimate his sentence would be around 10 years. They also put in a note that that wasn't formal and it could change if different information were obtained and would increase or decrease the length of time. And then not to mention that a plea agreement, even though the defendant signs off on the plea agreement, the judge has discretion. So a judge can take a plea agreement and see a plea agreement, and they could say, well, the prosecutors or the U.S. attorneys offered 4 years, and the judge looks at the plea and says, no, I'm going to give him 10. Ultimately, it does come down to the judge. Most often than not, they do go along the same lines as what the prosecutors offer, but they can deviate from that. So now the difference with this issue is that now we've gone through a full trial, and now we've done the full pre-sentencing report, which includes all kinds of information about Josh. And one factor that could play a considerable role in Josh's sentencing is that before the case, when he was arrested, he and Anna obstructed CPS's availability to actually meet with the kids, and they refused to allow forensic psychologists to speak with them, to do any sort of interviews, and they were not cooperating. Because of not cooperating, they could have been trying to impede on information being collected by the court, which could come back to bite him if the pre-sentencing investigation did find any conduct that would go along with this type of case. So that part could haunt him, and it also could haunt Anna, but it could increase his sentencing. So I'm sure some of you guys are asking what the enhancements are for these types of cases, and I can tell you that as well. So under the federal law, the guidelines for sentencing fall under what is a statute called 2G 2.2. So he's charged in the indictment with receipt and possession, but the sentencing is based off of trafficking in material which involves exploitation of children. Every single case starts at a specific base. So if he's convicted of one subset, he would have a base score of 18, and if he was in another one, 22. Receipt is 22, and so his base score when he starts at sentencing is 22. And then they can enhance the overall score, and then that score is then used with a diagram that helps to determine what the recommended guidelines for the sentencing would be, and that comes in, and that's where the criminal history comes into play. So if someone has more offenses, the more time they'll get. But the enhancements also increase the overall time of the sentence. So if you start from 0 and you go to 20 is kind of how the pendulum or the graph would work. So what they look at for this specific case, according to the guidelines, is that whether or not his conduct was limited to the receipt or solicitation of material, and that he did not intend to traffic it or distribute it. So this would be in the event that he simply was just downloading it and he had no interest in sharing it. I don't know if he'll actually get this one. He might, simply because he was in the peer-to-peer and they were able to download it directly from him. So technically, in a way, that's considered distribution because they were able to get it from his computer. So if he was only doing that and he wasn't distributing it and he wasn't part of a peer-to-peer network, they would actually decrease the level by 2. And then there is increases. So if the person is under 12, that increases his base by 2. And then they have other stipulations within that increase the score even greater. So if he made any sort of money off of it, that could increase the score. If he distributed in exchange for valuable consideration but not actual money, that can increase the score. If the offense involved distribution to another minor, that can increase the score. If it involved distribution to a minor that was intended to persuade, induce, or entice or coerce them, that can increase the score. And they pick just one of these of this 3. Or if they knowingly engaged in distribution other than distribution described in subdivisions A through E. So he could get 2 levels there based on the fact that he was in a peer-to-peer network. And we don't know, again, if he received any money or anything like that. That part, we just don't have a clue at this point. But that would play a factor. So if they find that he was engaging in transactional money, that kind of stuff, that could increase it. But it's more than likely that just being in the peer-to-peer would probably increase it by 2. Then he gets another increase because the content that he had included toddlers, and that's a 4-level increase. And then there is if they engaged in a pattern of activity that involves essay of a minor. And this is interesting because pattern of activity doesn't mean that they had to do anything to a child during the specific offense. It can be any conduct he's done that involves SA of a minor at any time in his life. They can add time on for that. Does that make sense? So whether or not he had a conviction under this rule doesn't matter. If he admitted to, and if he's done this to other minors, this can increase the level of his offense and the sentence because of the pattern of behavior. And the court ruled in the hearing, in the trial, that they were bringing in this evidence to show a pattern of behavior. And the magistrate judge, when they talked at the bond hearing, specifically said to Josh, your previous history concerns me based on what you've done. And that could play a factor in your sentencing. And that's where it plays a factor. So even though he wasn't convicted, they can still take it into consideration as long as it's taken as a fact by the court, which it was during trial. And then the next one would be based on if he used a computer, which he did. The next one is on the number of images. And according to the reports, the initial downloads that they got from him was around 66, but I believe Gerald Faulkner testified that they found over 200 total images on his computer and in the deleted files. So that would increase his base to a level 3 steps up. So hitting all of the enhancements based on the different factors here can put him in a really difficult position where he could potentially be pushing up against that maximum sentence. Will he actually get the maximum sentence? That's totally up to the judge. And again, the judge will determine, based on all the other factors of what was found in the investigation, on whether or not they will sentence for the maximum. I think the prosecutors in this, or the U.S. attorneys in this case, did a really good job of showing that this is a pattern of behavior. This is Josh's, like, it's escalated. It hasn't gotten better. And again, even though there wasn't a conviction, it can still impact the overall sentence in this case. He could be sentenced anywhere from 0 to 20 years. I know, it's wild. And they can go above that. So if the judge decides he wants to go above it, he'd have to prove it in court, but they can technically go above a mandatory if they feel like there's a risk or some mitigating factor that proves that he needs more time than that. But at this point, that's sort of where it starts, and he could sentence on both charges. Now, it's standard in the federal government that when they sentence on both charges that it's done concurrently, meaning the sentences run together. And because the crimes happened together, it's unlikely that the time would be consecutive unless there is another mitigating factor that the judge decides needs to have Josh behind bars for a longer period of time. For many people, a less than life sentence for Josh is going to be unhappiness because most people feel like he is not able to accept responsibility and therefore not redeemable and not reformable. And many in comments believe that it doesn't matter if he's only given 20 years. They believe firmly that he'll come out and he'll do it again. And unfortunately, that does happen. It doesn't happen all the time, but it does. So they can only go off of what they know and what they have to work with. And this is what the current guidelines state. So I'm not an attorney. I'm just simply providing you the information off the United States Sentencing Commission's website, and the judge and the prosecutors and everyone will all come together and figure out, the probation officers already figured out that level that they think that he should be at, which we don't know what it is. So could the level be 25 and, the prosecutors think it should be 38? That's where the differences in years can vary so drastically. So at the end of the day, he doesn't have to have any convictions, but if he did have a conviction, it would obviously increase. And the more convictions someone has, the more likely they are to serve life in prison. But he just doesn't meet that standard. And juvenile convictions don't count the same way that a conviction would count if it were an adult. I know this is not giving you a whole lot of answers, but I hope my research helps give you a little bit more information about how the sentencing will work, and we will know hopefully by April 5th, hoping they don't push this out like they have been. Some of you have asked, will the sentencing be open to the public? As far as I know, sentencing will be open. It will not, again, be filmed. There is no videos allowed in federal court. And due to the fact that there are child victims, it's a closed court, meaning no video, no audio, no nothing. So if people were to go, they have to go to the courthouse for that. And again, they haven't stated whether or not it'll be an open hearing or not. I would guess it will be public, but again, I'm not sure. So that's what I have for now, and I'm assuming the judge will be denying his requests shortly once Josh's attorneys respond. Josh's conduct too during the trial can play a factor. So the judge can also, I forgot this part, the judge can take into account anything that happened during the trial or any behavior he had during the trial that potentially either obstructed justice, caused problems in the court, if there was any intimidation of witnesses or tampering or anything that caused undue influence or coercion, that kind of stuff, they can also play a factor into that, and that can be considered by the judge for a sentence. So that was another stipulation as a part of his bond agreement, was adhering to all of the rules and not causing extra problems for the case. So that, again, we don't know. The judge, when he was remanding Josh into custody, did mention that Josh was a model parole or a probation guy. So he basically followed the rules while on probation. So I don't know what they could take into account, stuff that happened in court, which his behavior in court and not accepting remorse is not going to help him at all. All right, you guys, so tell me what your thoughts are in the comments below. Bye, guys.